Okay, the Equality Act 2010. Treating everybody the same increases the chance of discrimination. The purpose of the Equality Act 2010 is to ensure that reasonable adjustments are implemented for those who are at a detriment because of a protected characteristic. And the adjustment's purpose is to remove any detriment. Unlike a ramp in place of stairs, for example, the detriment might be a process that causes a difficulty, which in turn causes a detriment. For example, queuing for a neurodivergent person will reduce the engagement of neurodiverse customers because it causes psychological distress. The end goal is equal opportunity for all. If we don't recognise this, then we treat everyone the same and end up making no adjustments, for example, to allow access to a building or an event. And so by treating everyone the same, we actually exclude the very people for whom adjustments are required. Now, the Equality Act 2010 is a superior piece of legislation, meaning all activity must consider this act. Remove the detriment and you are likely to remove the discrimination. Now, positive action is actively encouraged. Section 158 brackets 1 prescribes that where an organisation wants to improve participation and engagement of those with a disability who is otherwise low, and there's a detriment to those people, positive discrimination is not prohibited, but it is actually encouraged. It goes on to say in section 158 brackets 2, it actually prescribes that positive action is a proportionate means of achieving the aim of A, enabling and encouraging persons who share a protected characteristic to overcome and to minimise that disadvantage. And B, is proportionate means of meeting those needs. And C, enabling or encouraging persons who share the protected characteristic to participate in that activity. Importantly, where a person is to be treated more positively for promotion over another, both parties must be as qualified for the promotion as the other. You can't just pick somebody because they're disabled. They have to be qualified, but also have a disability. Now, indirect discrimination. Additionally to section 13, direct discrimination and section 15 is discrimination arising from disability. You need to be very mindful of indirect discrimination. This is when a provision, a criterion, or a practice is applied which provides a detriment to a person with a protected characteristic, regardless of your intention. For a successful indirect discrimination claim, the provision, criterion, or practice must apply to those without the characteristic, so a blanket approach in most cases, and it puts or would put persons who share that protected characteristic at a particular disadvantage when compared with people who don't share that characteristic, for example. By considering and applying reasonable adjustments, you are actually likely to satisfy your legal duty. Now, recruitment and the Equality Act. Section 60, brackets 6, close brackets, open brackets, A, close brackets, provides no contravention where the business needs to establish the needs for reasonable adjustments for any assessment and interview. Now, importantly, in section 60, bracket 6, bracket A, It advises that merely asking about an applicant's health does not contravene the Act. What's important here is the conduct of the person asking on behalf of the business. That may contravene a relevant disability provision. Now, Section 60, brackets 1, prescribes that the organisation must not ask about a person's health before offering the applicant the role, which is in fact a very significant transaction within the process. Now, this is not a general don't ask before offering at any stage. This also applies to being added to a pool of applicants for future consideration. Now, the Equality Act 2010 and disability. The Act prescribes a duty not to discriminate against a protected characteristic, with the legal duty, this is quite key, commencing when you know or ought to know about the disability. Now, Section 6 of the Act defines disability as a physical or mental impairment which has a long-term adverse effect on the person's ability to carry out normal day-to-day activities. Schedule 1, brackets 2, defines long-term as having lasted for at least 12 months and is likely to last for a minimum of 12 months or lifelong. Schedule 1, brackets 5, states that where a person is receiving treatment or taking medication for the disability, then that person is to be treated as though not on medication or treatment. Now, moving quickly on to prohibited conduct. Discrimination can be direct or indirect, and intention is in fact irrelevant. It is the outcome that's really, really important. Section 13, direct discrimination, is where a person treats another less favourably because of a protected characteristic. And we're talking about neurodiverse conditions, but that could be age, gender, anything. Section 15, discrimination arising from disability, is where a person treats another unfavourably because of something arising in consequence of their disability. And it cannot be shown that that treatment by the organisation is a proportionate means of achieving a legitimate aim. Section 15, however, only applies when you know or ought to know that the person has a disability. And a key thing here is absence periods. If somebody's having days off sick, it could be seen as ought to know. So if that person's away from work a while, why you're not questioning them, that could be key there. Duty to make adjustments is quite key within the Equality Act. Now, Section 20 lays out the responsibilities about its duty to make adjustments. Where a physical feature, a provision, or a criteria, or a practice puts a person at a substantial disadvantage in comparison, however, to those who are not neurodivergent, then steps must be taken, as is reasonable, to have to avoid the disadvantage. Where a disabled person requires an auxiliary aid, and that auxiliary aid could be classified as a coach or a support person rather than just a physical device, then there is a duty to provide such an aid. Where, without such, then a disadvantage would occur in comparison to those without a disability. So, okay, what happens if you don't do anything about those adjustments? Section 21 addresses that. Failure to comply with duty to make adjustments. Where a requirement under Section 20 has not been complied with, whether in full or part, it is actually a failure to comply with the duty to make reasonable adjustments. A failure to comply means, therefore, there is discrimination contrary to the prescribed definition of the appropriate discrimination. Might be a disability, direct or indirect. Discrimination provision, section 13, 15 and section 19.